That's good, Pat. That's really good. But I need the glasses. Oh, that's really good, Pat.
Did it say start?
As it started.
Can you have to do it this way?
Start. Hello, ladies and gentlemen. My name is Louis Cohn. I'm proud to have been selected by CLE Guide, a premier provider of continuing legal education programs and seminars, to present a seminar on the attorney-client relationship from theoretical, ethical, and practical perspectives. By way of introduction, I received a Bachelor of Arts degree from Hobart College in Geneva, New York. I thereafter received a Juris Doctor degree from the University of Virginia School of Law, where I was one of the editors of one of the law reviews. I thereafter served a one-year appointment as law clerk to an Associate Justice of the New Jersey State Supreme Court. And thereafter, for 45 years, I served as a partner and lead trial attorney in several New Jersey law firms, in which I specialized in commercial litigation, labor and employment-related law, commercial transactions, and probate law and litigation. I was also very extensively involved in the New Jersey attorney disciplinary system. I served as chair for one of the district ethics committee. I was appointed as standing master by the state Supreme Court, and I was counsel both as a prosecutor and as a defense counsel for attorneys charged with disciplinary violations. I am pleased to be presenting today's seminar. I'd like to preliminarily express thanks to the law firm of Brown and Bunch in Chapel Hill, North Carolina, who have graciously allowed me to use their conference room for this seminar. Now, turning to the subject of attorney-client relationships. What can you say about these relationships? Well, the most basic adage is clients. You can't live with them, you can't live without them. But I have given this seminar on a number of occasions in different forms, and the most basic question I get asked at the outset of this seminar is, why do we need a seminar on the attorney-client relationship? It's something we all do. It's something that we think we're conversant with. But when I ask attorneys, how well do you interact with your clients? The answer that I invariably get is, I hope I'm doing it all right. And the plain fact is that law schools and legal employers, whether they be public or private, have failed to address, much less provide guidance and instruction as to how to deal with clients. And I want you to go back to when you were in law school. We all took courses on contracts, property, torts, constitutional law, civil procedure. But did you take any courses on the attorney-client relationship? In fact, I did my own informal survey of law schools throughout the country, and I could not find one law school that had a course of study entirely devoted to the attorney-client relationship. They dealt with certain aspects of the relationship, for example, how to interview a client, But did you ever get instruction on the theory and ethical and practical aspects of dealing with clients? And the answer probably is no. Think about when you got your first job in the legal profession. Most employers, most law firms, most government offices just throw attorneys into the breach and hope that they learn about the attorney-client relationship on their own. And just as you're taking a continuing legal education course with me today, most of us have taken continuing legal education courses. But how many have taken any course devoted to the attorney-client relationship? You know, when I have taken courses and when I've spoken to colleagues who have taken courses, they generally take one of two types of courses. They will take a practical how to do it course. In other words, how to do a deposition, how to conduct a cross-examination. Or they will take a course on a substantive area of the law, or for example, a new statute. I know in New Jersey, about 20 years ago, the state enacted a Consumer Fraud Act. We all took courses on the Consumer Fraud Act. But I don't think any of us have taken a continuing legal education course on the attorney-client relationship. And just by your choice of taking this course, I commend you. And the reason that this surprises me is that clients are the one common denominator that we all have in the practice of law. It's true whether you're in the public practice of law for a government entity or you're in the private practice. And it's true whether you're doing litigation or non-litigation. And even if you do not choose to engage in the practice of law, knowing how to deal with a client is an important aspect of what we all do in our everyday lives. But there's also a very dark side of not learning about the attorney-client relationship. And I'm going to give you a statistic. It is true, this statistic holds true in most states, and it certainly holds true on a national level. For every incoming attorney who's admitted to the bar, they can expect at least 3 times during their career to either be the subject of a legal malpractice action or an ethical grievance. That's a sad statistic. And the plain fact is, the majority of these claims that are brought against attorneys every day, in every state, in almost every court, the plaintiff is a client. It is not a judge. It is generally not an adversary attorney. It is a client. So that unless we abide by what is required in terms of dealing with our clients, we run the risk of adding to that statistic. People ask me, why have I chosen to give this seminar? Well, I must admit, I have an ulterior motive here. And once I say I have an ulterior motive, people tend to listen more closely. And that ulterior motive is to impress upon you, the audience, the importance of adopting a more encompassing, holistic view of the attorney-client relationship to engage and empower your clients to be your ally and not your adversary. As a New Jersey native, I also wish to impress you with my astonishing command of the English language. Where do we start? Well, we start looking at the attorney-client relationship from a purely theoretical perspective. And in looking at the theory behind, or the theories behind the attorney-client relationship, we start with a book entitled Lawyer and Client, Who's in Charge? This was written and published in 1974 by a then district attorney in New York City by the name of Douglas E. Rosenthal. If any of you has fantasies about reading this book, let me dissuade you from doing this. First of all, the book is generally out of print, which is a mercy to the legal profession. It is truly one of the most boring books that can be found on the face of the earth. And I am convinced that criminal authorities give copies of Mr. Rosenthal's book to hardened criminals who don't respond to solitary confinement. That aside, Mr. Rosenthal's book was the first empirical study of the attorney-client relationship. And what he did was review a series of personal injury actions that had been brought before the New York State courts, principally in New York City. And he reviewed the attorney-client relationship in terms of the degrees of client participation in the litigations and how that affected the client's perception of how well or how poorly he was served by his attorney. And in his book, Mr. Rosenthal postulated two models of the attorney-client relationship. There was the traditional relationship, which was defined by the attorney totally dominating the relationship. Quite honestly, in Mr. Rosenthal's traditional model, the client played an essentially passive, deferential role to the attorney. He allowed the attorney to define the objectives, the means of achieving those objectives, and evaluating how closely the objectives were met. And there were a number of variables that Mr. Rosenthal looked at. Some of them related to the severity of the personal injury. Some of them dealt to inherent conflicts of interest between the attorney and the client, and also the client's access to alternative legal services. And in his book, Mr. Rosenthal began to perceive that there was a new and different model to the attorney-client relationship. He couldn't fully explain the changes, but he was aware that changes were taking place. And part of the reason why he couldn't fully understand why there were changes was because his book was written right in the middle of the Watergate crisis. And the Watergate crisis changed the way that clients looked at attorneys. To be honest with you, they distrusted attorneys after Watergate. And the other thing that caused a change in the traditional model of the attorney-client relationship was the fact that as time passed, remember, Mr. Rosenthal's book was written in 1974. As time went by, there was a greater and greater demand by consumers, and this included the attorneys who they retained. And what Mr. Rosenthal perceived as a result of these changes was that there was a new model, a different model. He called it the participatory model or contract model. And in this model, the attorney and the client shared an inherent skepticism and distrust of each other. And what they did was they negotiated the parameters of the relationship as they moved forward. Now, in his book, Mr. Rosenthal looked to a number of indices or issues that typically affect the attorney-client relationship. One was how they characterized the relationship. In the traditional model, it was one-sided. Total responsibility was arrogated to the attorney. In the participatory or contract model, the attorney and the client negotiated their respective roles in the relationship. There was differences in the appropriate client behavior. In the traditional model, the client was essentially passive. There was a total delegation of responsibility to the attorney. In the participatory model, the client played a more active, skeptical role in an effort to be informed and participate in the legal process. Resolution of professional problems. In the traditional model, all the technical solutions were inaccessible to the client, and all the resolution of problems were done by the attorney. In the participatory model, different issues were relegated to the client, and certain issues were delegated to the attorney. The client would define the objective of the relationship, and the attorney would select how those objectives were achieved. There was a difference as to how people perceived the professional standards to guide the attorney's services. There was an assumption in the traditional model that there was a high standard of practice by every attorney, and only the attorney could define that. With the traditional model, the participatory model, there was no assumption of high standards, and they would be defined generally by the parties as they went through their relationship. In addition to these two models, I read an insightful article. It was published in the Fordham Law Review entitled "A Religious Perspective on Legal Practice and Ethics" by a Joseph Allegretti. It's at, if you're interested, 66 Fordham Law Review, 1101 in 1998. Now, in his article, Mr. Allegretti, in essence, defined a third model. He called it a covenantal model. Now, admittedly, Mr. Allegretti approached his subject from a distinctly Roman Catholic view. And that was the emphasis of his article. But if you read the article, you can see a new model being devised. In the covenantal model, the attorney and the client trust each other. In fact, they regard themselves as being dedicated to achieving mutual goals. The appropriate behavior by a client under the covenantal model is there is joint partnership and participation in the process. Resolutions of professional problems, the client and the attorney share responsibilities for defining and, more importantly, redefining objectives and selecting means of achieving those objectives. And by professional standards under the covenantal model, there is joint participation to make sure that the professional standards that the client expects and the attorney hopes to give are present. And the most notable difference between this new covenantal model and the original traditional model or participatory model is under the traditional model and the participatory model, the relationship between attorney and client was a one-time affair. The client would retain the attorney, and then that was it. But in the covenantal model, based on the parties' relationship with each other, there was an ongoing relationship, and it was expected that the parties would continue to interact even after the initial matter was concluded. Now, most of my audience say, why are you boring us with these theoretical models? The reason is, if you read the commentary that has blossomed since Mr. Rosenthal first published his book in 1974, you see a gradual movement to the covenantal model. And in fact, if you follow the rules of professional conduct promulgated by the American Bar Association, you see that they have envisioned and adopted standards which essentially parallel the covenantal matter. And in turning to the ethical perspectives of the attorney-client relationship, I'd like to focus on 3 RPCs. The first one is RPC 1.2, which is entitled Scope of Representation and Allocation of Authority between Client and Lawyer. And if you get a chance, I urge you to read RPC 1.2a. And if there's anything that you get from this seminar, it is the cardinal rule of RPC 1.2a and how it defines the attorney-client relationship. And it states, quote, "A lawyer shall abide by a client's decisions concerning the objectives of representation and shall consult with the client as to the means by which they are to be pursued." I regard this as so important. I'm going to read it again just to emphasize it. Quote, "A lawyer shall abide by a client's decisions concerning the objectives of representation and consult with the client as to the means they are to be pursued." Remember, under the traditional model, the objectives and the means of achieving the objectives were left to the attorney. Under the participatory model, the client defined the objectives, the attorney defined the means of achieving them. But under RPC 1.2a, it is the client who defines the objectives and who participates in how they are achieved. And the comments to RPC 1.2a emphasize that an attorney shall not only consult with the client as to the objectives, but by the means that they are to be achieved. Now, the RPC commentary from the ABA acknowledges that from time to time, clients and attorneys may disagree as to the means of achieving objectives. And they point out in the commentary that clients will usually defer to their attorneys on technical, legal, and tactical matters, although I will consider a case later in this seminar where that didn't happen. By the same token, the commentaries observe that attorneys usually defer to clients as to the expenses that are to be incurred or how third parties may be adversely affected by the decisions. The commentary urges the attorneys to try to reach a, and I put in quotes, mutually acceptable resolution, close quote, of such issues. But the commentary also recognizes that where the parties cannot resolve their differences, the attorneys under certain circumstances reserve and retain the right to withdraw, and we will talk about this later in this seminar, and the client retains the right to discharge the attorney. In terms of the objectives that are set by the client, the RPC, and I'm pointing to RPC 1.2c, recognizes that an attorney can limit the representation if the limitation is reasonable and with the client's informed consent. And I caution you that that you do this at the outset of your representation, because once you are engaged, it is more difficult under the RPCs to withdraw. I also caution you that any client who defines the objective of the representation as, I want to fight for the principle of this matter, this is not a client you want to retain. The RPC 1.2D makes clear that in accepting the objectives of a client, an attorney cannot do anything that will involve criminal behavior, fraudulent behavior, or will involve the attorney in engaging in conduct that is prohibited by the rules of professional conduct. And the ABA commentary notes there's a critical distinction between presenting an analysis of questionable conduct and recommending the means by which a crime or fraud might be committed with impunity. The next RPC that I want you to focus on is RPC 1.4, which is entitled simply Communications. And the RPC 1.4 sets forth a number of to-do obligations on the part of the attorney. The attorney must provide the client with information to enable the client to reach a decision consistent with informed consent. And in a couple minutes, I will talk about the concept of informed consent. And the ABA commentary makes clear that reasonable communication between the lawyer and the client is necessary for the client to participate in the representation. The RPC 1.4 requires an attorney to reasonably consult with the client about the means by which the client's objectives are to be accomplished. And they recognize that there may be circumstances, for example, right in the middle of a trial, where an attorney may not be able to consult with the client consistent with this obligation. But what the RPC commentary makes clear is that as soon as possible, after the immediate circumstances have passed, the attorney should sit down and talk with the client about this issue. RPC 1.4 requires an attorney to keep the client reasonably informed about the status of this matter. They recognize that in certain circumstances, an attorney may make exceptions to this otherwise general obligation. For example, if an attorney is dealing with a psychiatrist who has examined the client and the psychiatrist indicates to the attorney that it might not be a good idea to disclose certain information imparted by the psychiatrist, the attorney is excused from passing this along to the client. There may be rules or court orders that may similarly prevent an attorney from giving immediate disclosure. But as a general rule, the attorney must reasonably consult with the client about the matters that are the objectives of the representation. RPC 1.4 further requires an attorney to promptly comply with reasonable requests from the client for information. That's res ipsa loquitur. It stands for itself. If a client asks you a question, you have to respond. And the RPC 1.4 finally deals with the requirement that an attorney promptly advise a client about, and I put in quotes, relevant limitations imposed by the RPCs on the attorney's conduct. In other words, if you are aware that the RPCs prohibit you as an attorney from taking certain action that the client wants you to take, you have to explain why you are not able to do that. And finally, the RPC 1.4 requires an attorney to explain a matter in quotes to the extent reasonably necessary to permit a client, again in quotes, to make informed decisions, close quote. What does that mean? if you're dealing with the chairman of the board of General Motors, the amount of explanation and the amount of disclosure may be less than if you're dealing with someone with little formal education. The message is dictated by the audience. There's one more RPC that I want to focus on, and it's RPC 2.1, which is entitled simply Advisor. And the RPC 2.1 imposes two obligations on the attorney. Number one, the attorney shall, I emphasize the word shall, exercise independent judgment, professional judgment, and render candid advice. And the commentary to this recognizes, in presenting advice, a lawyer endeavors to sustain the client's morale and to put advice in as acceptable a form as honesty permits. However, a lawyer should not be deterred from giving candid advice by the prospect that the advice may be unpalatable to the client. The second part of RPC 2.1 states that a lawyer may, and I put in quotes, refer not only to the law, but to other considerations such as moral, economic, and ethical considerations that may be relevant to the client's situation. And this includes political matters as well. The attorney is being approached by the client for candid, honest advice. The advice may impinge not just on legal matters, but moral, ethical, and political matters. And the attorney, to the extent that he feels comfortable, should feel free to draw on these other resources to give an informed decision to the client. At this juncture of the seminar, I often get questions, particularly from my colleagues who do a lot of medical malpractice work. And they say, has the legal profession moved to an informed consent standard? And the answer is absolutely yes. If you have any doubt about it, look at RPC 1.0, which deals with terminology of certain terms that are referred to throughout the RPCs. And one of them is informed consent. And according to RPC 1.0E, informed consent denotes the agreement by a person to a proposed course of conduct after the attorney has communicated adequate information and explanation about the material risks and reasonably available alternatives to the proposed course of conduct. And again, in giving this definition of informed consent, the commentary to the RPCs says that the attorney must make an assessment whether the client is a person experienced in legal matters generally, and whether the client is independently represented by other counsel in giving the consent. The commentary further points out that in obtaining informed consent, an attorney will usually and almost invariably require an affirmative response by the client or other person. In general, an attorney may not assume consent from the client by that client's silence. And if you look at the RPCs, you will see a number of them have adopted the informed consent standard. I previously mentioned that an attorney can limit his representation of the client under RPC 1.2C, but he can only do it if he has the informed consent of the client. Under RPC 1.4, dealing with communications, the attorney under RPC 1.4B must explain the matter to the extent reasonably necessary to permit the client to make informed decisions. An attorney cannot reveal information relating to his representation of the client unless the client consents after consultation. An attorney may, under RPC 1.7, represent a client notwithstanding a concurrent conflict of interest if each affected client gives informed consent. Now, I mentioned previously that generally when it comes to the means of achieving a particular objective, the RPCs encourage the attorney and the client to work cooperatively. But there was a recent decision, it was in 2018, by the United States Supreme Court, which created a new constitutional dimension for the attorney-client relationship. The case was McCoy versus Louisiana. It's at 158 U.S. Reporter. Unfortunately, I do not have a beginning page number. It is at 138 Supreme Court Reporter, 1550, and 200 lawyers at second at 821. And this case defined the constitutional dimension, and in this case, it happened to be the Sixth Amendment, to a client's right to define the objectives of the attorney's representation. It was an unusual set of facts here. The defendant had been accused of first-degree murder of his estranged wife's mother, stepfather, and son. The defendant pled not guilty to all three charges. And he had an unusual alibi. He claimed not only that he was out of state at the time, but that it was corrupt police officers in his hometown that actually had killed the victims when a drug deal went wrong. When it got to trial, the defendant insisted on giving this alibi. The attorney objected, and he cautioned the defendant that it was such a far-fetched alibi that it was not likely to prevail. The defendant made a motion to discharge the attorney, and because it was made shortly before trial, the trial court denied it. When they went to trial over the defendant's express objection, the defense attorney advised the jury that defendant had committed the murders, but that he lacked the mental capacity necessary to satisfy the intent of first-degree murder. When the defendant took the stand, as he did, he testified he was innocent, and he asserted his ill-conceived alibi defense. Needless to say, the jury found the defendant guilty of all three murders. At the penalty phase of the case, the same thing happened. The attorney advised over the defendant's objection that the defendant had committed the murders, but that he lacked the mental capacity to knowingly do so. The defendant stuck to his alibi. The jury, not surprisingly, returned 3 death verdicts. On appeal, the Louisiana State Supreme Court found that the defense counsel had the authority to concede guilt, notwithstanding his client's objection. The case was taken up on certiorari by the U.S. Supreme Court, and the appeal was decided by a 6-3 majority in favor of reversing the guilty plea and the death sentence and remanding to the state court for further proceedings with the Supreme Court's decision. The majority opinion was not surprisingly written by Ruth Bader Ginsburg. She was joined by Chief Justice Roberts and Justices Kennedy, Breyer, Sotomayor, and Kagan. And at the outset of the majority opinion, Justice Ginsburg made clear that the usual type of Sixth Amendment claim for lack of effective counsel was not applicable because this case did not involve defense counsel's competence. In addressing the Sixth Amendment, Justice Ginsburg went further and for the first time stated that a criminal defendant is entitled to the assistance of counsel for his defense, quoting right from the Sixth Amendment. And she made several significant statements. First, she stated, quote, "The choice is not all or nothing. To gain assistance, a defendant need not surrender control entirely to the counsel, for the Sixth Amendment, in granting the accused personally the right to make his defense, speaks of the assistance of counsel. And as an assistant, however expert, a lawyer is still an assistant." Justice Ginsburg went on to say, just as a defendant may steadfastly refuse to plead guilty in the face of overwhelming evidence against his or her beliefs, or reject the assistance of legal counsel despite defendant's own inexperience and lack of professional qualifications, so may the defendant insist on making his or her innocence at the guilt phase of a capital trial. These are not strategic choices how best to achieve a client's objectives. They are the choices about what the client's objectives, in fact, are. Finally, Justice Ginsburg held that a violation of a defendant's Sixth Amendment secured autonomy ranks as an error of the kind that our decisions have called structural. When present, such an error is not subject to the harmless error standard. What are the takeaways from Justice Ginsburg's majority opinion? Well, number one, this is the first time in my reading that a court has recognized that a client's autonomy to define the objectives of his representation by his attorney is of constitutional dimension. Second, Justice Ginsburg recognized that by virtue of the attorney's failure to abide by what the client wanted, the client was entitled to a new trial without any need to show prejudice. There was a dissent in this case written by Justice Alito, who was joined by Justices Thomas and Gorsuch. Justice Alito observed that because the attorney indicated that the defendant lacked the mental capacity to knowingly admit or deny guilt, the attorney really had not acted contrary to the client's wishes. Justice Alito also observed that this was a very rare case where a client did not abide by the attorney's suggestions and instead came up with a cockamamie defense. But Louisiana versus McCoy, I stand corrected, McCoy versus Louisiana stands for a new proposition that the client's right to define the objectives of the representation are of constitutional dimension. It's not only required under any covenantal model of the attorney-client relationship, it's not merely required by various rules of professional conduct, it is now of constitutional dimension. This turns to the last aspect of my seminar today, which are the practical perspectives of the attorney-client relationship. And to put you in the appropriate mood for this part of the seminar, I want to give you an image. You see me standing on the shore of the Hudson River in Weehawken, New Jersey, just a couple paces from where Alexander Hamilton was shot by Aaron Burr. I have a flowing white beard. I have flowing white robes. I carry in my right hand a staff. And as I approach the banks of the Hudson River, the waters part, giving me unimpeded walking room to New York City. And as I approach New York City, you notice that I'm carrying in my left hand 2 tablets. And on the 2 tablets are what I call Lou Cohn's 10 Commandments of the attorney-client relationship. It's a powerful image. Commandment number 1. If you are accepting a representation or contemplating, you must do a thorough conflicts check. If there is a conflict in your representing this client, it's better to find out right up front than to get several months, if not years, into the representation and then advising the client that you have to withdraw. Commandment number 2, use your retainer agreement to define the relationship. And there are a couple points that I want to bring out about the retainer agreement. First of all, define the objective of the relationship. As I mentioned earlier, and as now as of constitutional dimension, it is the client who defines the objective. And if you're putting it in the retainer agreement, please be ultra specific. Because if you don't, you're going to run a risk down the road where you think you have been retained to perform tasks A, B, and C, and the client will then come back and say, oh no, you also agreed to do D, E, and F. Be specific. When necessary, exclude certain items. For example, whenever I was accepting a representation for a trial, I made clear that my retainer agreement clearly indicated that I was not necessarily going to handle any appeals, and include disclaimers as to the objective. Phrases like, except as specifically set forth in this agreement, the attorney will not perform any other objectives. As part of your retainer agreement, be clear to clearly define the commencement point of the representation. If you are going to be doing it simultaneous with the execution of the retainer agreement, that's fine. But I know that many civil attorneys, many criminal attorneys, require a defendant to pay an upfront retainer fee. And they believe that until they are paid, they are not retained. But if that is the case, you should define it in your retainer agreement. You should say, representation will begin upon payment of the $25,000 retainer fee. Your retainer agreement should be clear as to the financial terms of the relationship. If there's a retainer fee, it should be set forth. Many agreements require the replenishment of the retainer fee so that there's always a fund available to the attorney to satisfy his fees. If you've demanded $25,000 up front and you want the client to replenish it, you have to set forth in the agreement. The agreement should set forth the basis for compensation. If it's contingent, say so. If it's hourly billing plus cost, say so. If there are revisions to the fee during the course of the representation, they should be anticipated in the retainer agreement. Many attorneys represent clients over the course of months or years, during which the attorney's billing rates may be changed. If they are to be changed, you should mention it during the course of preparing the retainer agreement, and you probably should mention it to the client when the rates are changed. The retainer agreement should include a projection of anticipated fees and expenses. It's not uncommon in my practice that clients come to me all full of vim and vigor until several months when the cost and the fees build up. And you should have, to the extent possible, a projection of the fees that may be anticipated during the course of the representation. And finally, when you're dealing with the financial terms, you should specify the consequences of a client's failure to abide by the financial terms. If the client stops paying the bills, the attorney should reserve the right to discontinue and withdraw from the representation. The retainer agreement should also have a provision of the consequences of the client to inform the attorney accurately and honestly of the facts. If a client has lied and the case goes south because of that, you should have that specified in the agreement. You should also have a provision requiring the client to reasonably cooperate during the course of the representation. Commandment number 3, communicate timely, communicate frequently. And these just go back to the obligations of RPC 1.4 that I previously discussed with you. And that not only includes communications of good developments, but timely advice of problems that arise during the course of the representation. If something goes wrong, you should tell the client right up front. Commandment number 4, not only do you communicate frequently, you document frequently. And this goes back to what we saw in the terminology of the RPCs under 1.0. There is an RPC that defines confirmed in writing. There is an RPC terminology which defines writing and written. And if you look at the RPCs, there are a number of RPCs that specifically require an attorney to confirm certain communications in writing. If the attorney has not previously represented a client on a regular basis, the fee agreement must be, in quotes, communicated in writing. Contingency fee agreements shall be in writing. That's the RPC 1.5C. Again, if there is a concurrent conflict of interest, the attorney must get not only the informed consent of each affected client, but must get it in writing. Commandment 5, teaming with the client. What do I mean by teaming with the client? You want to make the client your ally. You want the client to feel a participant in the representation process. I personally like to delegate non-legal responsibilities to clients. If something has to be retrieved from a doctor or an expert, I let the client do it. And I encourage input by the client. I frequently go to a client and I say to them, what do you think? Now this deals with the passive or reluctant client. And where you have a client who just says, I'll go by whatever you say, I make sure that whatever I say is in writing. Commandment number 6, listening to and abiding by the objectives and wishes of the client. And I have a quick story to tell on this one. I represented a widow who buried her husband in an above-ground concrete mausoleum. Several months after her husband was interred, the client, the widow, went to the cemetery on Father's Day and to her shock saw the outer side of the mausoleum stained. What had happened? Her husband had leaked. There were bodily fluids left in her husband, and they leaked and they penetrated to the outside of the mausoleum. The widow was brought to my office by her children, who were gung-ho for claims of emotional distress. We filed a lawsuit. We survived several summary judgment motions, and we were on our way to presenting one wonderful emotional distress case. And one day, out of the blue, I got a phone call from my client. She was crying. She was frankly weeping hysterically. I said to her, "Mrs. Smith, what's the matter?" She says, "I can't do this anymore. We got to stop this." I said, "Stop what?" She says, "I just don't want." She says, "The only thing I want," she says, "I don't care about emotional distress. All I want is a new mausoleum." It made it very easy to settle the case. Not only did the client get what she wanted, she understood that I had abided by her objectives. Commandment number 7. You must do periodic reassessment of the representations and the objectives. Things happen, both good and for bad, during the course of the representation. You and the client must constantly sit down, say, where are we going and how are we going to get there? Because the initial objectives and the initial means for this objective, as a result of motion, practice, discovery, may no longer be true when you get to the end of the case. Commandment number 8. Timely bill and collect. There was an attorney in New Jersey who had a favorite phrase: the unbillable life is not worth living. It may be very aspirational, but the bottom line is, don't nickel and dime your client. I made it a personal practice not to bill for phone calls and correspondence. Why? Because I wanted the client to feel free to call me without thinking that the meter was running. Commandment number 9. The client is always right, except when he is wrong. And this, I refer you to RPC 1.16, which deals with declining or terminating representation. If the client is seeking criminal objectives, you may withdraw. If he is seeking fraudulent objectives, you may withdraw. If he is asking you to disobey the rules of professional conduct, you may withdraw. I have another one. I have 1 strike and you're out. Actually, it's 2 strikes. If a client gets abusive to me, no attorney should have to put up with an abusive client. The first time he gets abusive, I warn him, and the second time I withdraw. Commandment number 10. Embrace the client. Look at him not as an adversary, look at him as a friend. And if you do so, the covenantal model of having a long-term relationship will come true. Now, why is a presentation on the attorney-client relationship necessary? Well, we don't want to be sued for malpractice, and we don't want to be the object of an ethics grievance. To the contrary, we want to engage and empower the client. But there's a broader reason, and I cite the classic constitutional case of McCulloch versus Maryland, which was decided in 1819. It's a classic decision by Chief Justice John Marshall. And in that case, the United States had chartered the Second Bank of the United States. The state of Maryland decided to tax the bank, and it went up to the Supreme Court on whether a state could tax an instrumentality of the federal government. Maryland said they could do so because it was establishing a bank was not among the enumerated powers granted to Congress. But Chief Justice Marshall, for a unanimous majority, said, number one, the government had the power to do this under the necessary and proper clause, which is Article 1, Section 8 of the Constitution, that Maryland couldn't tax an instrumentality of the government used to exercise constitutional powers, but to emphasize the importance of what he was doing. Chief Justice Marshall wrote, quote, "We must never forget that it is a Constitution that we are expounding," close quote. Why did he say that? He wanted to impress upon his brethren and the readers of the opinion that there was a higher calling of the court. They were not trying to enforce some regulation or statute. They were enforcing the Constitution. And similarly, as we approach the attorney-client relationship, we're not doing it as bricklayers or ditch diggers. We're doing it as members of a very noble profession. We are regarded under the law as fiduciaries. And as fiduciaries, we must adhere to the requirements that I've set forth for the attorney-client relationship. This ends my seminar. I thank you for listening. I hope that you've gotten some benefit tips from here, and I encourage you to communicate with CLE Guide, the provider of this seminar, with your comments so that if I am asked to give this again, I can make it even better. I thank you.
Did it work?
Although I'm still on the screen.
So you would be.
Okay.
Does it say recording at the top still?
Yes, it does.
I wonder if it's because the hour's not up. And